Okay, so I wanted to read this because I thought it was quite interesting and worth talking about. So, this is from The Reactionary, which is from Substack, from a guy named Techno Fog. So, DA Fani Willis violates the law, her remarkably dishonest attempt to violate civil liberties and deceive the Georgia court. Fulton County District Attorney Fani Willis has gone from criminalizing court filings to committing crimes with respect to her own court filings. Remember, she's already broken the law when they published that the charging documents that they claimed. First, they said it was a mistake, which means if it was a mistake or it was a fake document, that's what they said. Initially, it was a fake document. And if that's true, then that means somebody posted a fake document to a government server, which is illegal. And so somebody did that, which means they created a fake document and then put it on a government server, which is illegal, or they hacked the government server and put on a fake document, which is illegal. Except then she came back and said, oh, it was a mistake. They didn't mean to hit send. So that means you lied in your other statement, which you also put on a government computer. So you committed a crime no matter what. So this isn't her first crime. This is this multiple criminal actions by this woman. All right, back to the current article. Georgia law makes it unlawful to knowingly file a court document, quote, knowing or having reason to know that such a document is false, contains a materially false, fictitious, or fraudulent statement or representation. Hey, look at that. That also applies to the other thing that they did. DA Willis is well aware of this law. She charged a number of defendants, including Donald Trump, Rudy Giuliani, and John Eastman, with a violation of that law for filing a document that contains a, quote, materially false statement in federal court, end quote. And she just violated it this week. All right, I'm not going to read everything from here, but I'm going to read the highlighted portion of it because this is the part that matters. So count 15 of 41. Unlawfully conspired to knowingly file, enter, and record a document titled Certificate of the Votes of the 2020 Electors from Georgia in a court of the United States, having reason to know that said document contained the materially false statement, quote, we the undersigned, being duly elected and qualified electors for President and Vice President of the United States of America from the state of Georgia, do hereby certify the following. So remember, that's what she claimed was a materially false statement. For background, Georgia law allows for a speedy trial demand in accordance with the Sixth Amendment, which provides that, quote, the accused shall enjoy the right to a speedy and public trial, end quote. Two defendants, Kenneth John Cheesebro and, I hope I said that right, and Sidney Powell, have made that request pursuant to Georgia law. DA Willis responded to these speedy trial demands with an utterly false motion to advise to inform the court and the defendants of the consequences of their requests for a speedy trial. The motion was in violation of 1610-20.1B1. By no means we are making a stretch. The statutory violation are clear and obvious. DA Willis and her team invented legal theories and misled the court about the relevant case law that allegedly supported her position. Let us explain. DA Willis made four main assertions in her motion, quoted in full below. 2, the procedural posture of the case has been dictated by defendant's speedy trial demands, as will be defined in front under Georgia law. The defendant's decision to file a speedy trial demand limits certain of their options in this case, namely, 1, the defendants cannot now argue that they are entitled to state's discovery response 10 days in advance of the trial, Smith versus State, 257, Georgia. I'm not going to read all that case stuff. The defendants cannot now argue that they are entitled to notice of the state's similar transaction evidence 10 days in advance of the trial, Brown versus State. The defendants are now precluded from calling any witnesses whose statements were not provided to the state less than 10 days in advance of trial, Clark versus State. The defendants cannot now complain that they have received less than 7 days notice of the trial date in the case of Linkhouse versus State. All these statements are demonstrably false. First, DA Willis alleges that because defendants' speedy trial demand, they, quote, cannot now argue that they are entitled to state's discovery responses 10 days in advance of the trial, Smith versus State, and Ruff versus State. This is not true. Georgia law requires DA Willis to produce a broad spectrum of evidence, quote, no later than 10 days prior to trial, end quote. Georgia Code 176-4, a defendant's request for a speedy trial does not waive this obligation. Of course it doesn't. Why would it? How can she even say that with a straight face? Furthermore, the defendants are not precluded from arguing they are entitled to evidence under Georgia law by the mere fact they requested a speedy trial. These cases Those cases DA Willis cites in support of her position, they do not apply. They do not stand for the claim DA Willis says they do. The Smith case involved a criminal defendant that requested a continuance. The Ruff case had to do with the defendant rejecting a continuance offer from a trial court when the state did not disclose witnesses in a timely manner. Neither case precludes the ability of a defendant to object late disclosure of evidence. Yeah, of course not. Second, the DA Willis states that, quote, the defendants cannot now argue that they are entitled to notice of the state's similar transaction evidence 10 days in advance of a trial. Again, that is false. Rule 31.1 requires DA Willis to provide notice of intent to present similar transactions to be given, quote, given and filed at least 10 days before the trial unless the time is shortened or lengthened by the judge, end quote. The defendants did not waive their obligation to benefit DA Willis. It still exists, and it still binds DA Willis. The case DA Willis cites, Brown versus State, does not stand for the proposition that this requirement is waived by a speedy request for a speedy trial. In fact, both the Brown case and Rule 31.1 contemplate the necessity of briefing and arguments where the 10-day notice is violated. Third, DA Willis alleges that request for a speedy trial precludes the defendants from, quote, calling any witnesses whose statements were not provided to the state less than 10 days in advance of a trial, Clark versus State. Another falsehood. Georgia law allows for this 10-day witness statement requirement to be shortened or lengthened, quote, as the court permits. Georgia Code 1716-4. 7, excuse me. Whether witnesses are excluded for a violation of this notice rule is up to the judge. There is no outright preclusion as alleged by DA Willis. And again, the case DA Willis cites just doesn't stand for what she says it does. Clark versus State involved a criminal defendant who violated that 10-day witness statement requirement. The trial judge in Clark gave the defendant the option of not calling the witness or the ability to continue his case at a later date so the witness could testify. There is no outright prohibition from calling a witness where the statement was produced with less than 10 days from trial, as maintained by DA Willis. Fourth, Willis claims the defendants cannot now complain that they received less than 7 days notice of the trial in this case, Linkhouse versus State. False. Rule 32.1 requires notice of the trial date not less than 7 days before the trial date or dates. This notice requirement, which falls on the court, exists to protect the due process rights of a criminal defendant. The surprise of a trial date means an attorney cannot effectively represent their client. It does not go away where a speedy trial demand. And as you might have guessed, the case cited by DA Willis does not stand for the proposition that a speedy trial demand means a criminal defendant waives a 7-day trial notice. The case cited by DA Willis is Linkhouse versus State, which concerns the remedies where there is a violation of Rule 32.1. It doesn't excuse noncompliance with Rule 32.1. At a minimum, the motion from DA Willis was deserving of sanctions. The trial judge, however, denied the motion without full briefing from the defendants. He wasn't concerned with accountability. Finally, you might be curious about the purpose of filing from DA Willis. Here's our guess. DA Willis plans to violate her discovery obligations. She doesn't want to take the case to trial within the timeline the speedy trial demands afford. Cheesebro is set for trial on October 23rd, 2023. Thus, she will violate her discovery and notice requirements, putting the defendants in the tenuous position of either proceeding to trial without adequate notice or having to continue the case at another date so they may be adequately prepared for trial. This is nothing more than dishonest gamemanship. It is violation of Georgia law and an affront to prosecutorial ethics. If DA Willis wants to punish false statements to a court, she should turn herself in. Yep, I would have to agree with that. And remember, this all started with her flat out lying about the charging documents and then creating a official statement saying that that was a fictitious document and then admitting it was real and all of the charges that were on there were the ones. And it also proves that they were going to charge no matter what, that the grand jury was just an exercise in futility, that this is just a made-up show trial. So there we go. More evidence. So now we have the DA violating the law multiple times, just like Jack Smith. Jack Smith's broken his own standards of fraud. So, I mean, it just goes to show the Democrats have nothing, and the only thing they can do is to try and cheat to win, which is so pathetic because they claim that Donald Trump is hated and disliked. Then why do you need to cheat to beat him?